seated. Council may approach.
Mr. Chief Justice, and may it please the court, my name is Alexandra Vernon, and I, along with my co-counsel, Gabriela Gallego, represent petitioner, the United States of America. Ms. Gallego will discuss the two Fifth Amendment issues, and I will discuss why the Confrontation Clause is not violated by admitting this translation. I'd like to reserve 2 minutes for rebuttal.
So noted.
The scope of the Confrontation Clause is not unlimited. It only affords criminal defendants the right to confront witnesses against them. Accordingly, petitioner respectfully requests that this court reverse the decision of the 14th Circuit Court of Appeals for the following two reasons. First, because Eric Moltz is not a witness against Ms. Spector, she does not have a constitutional right to confront him. Second, the appropriate test is the language conduit theory, and using those four factors, they slide in favor of the government, and so the 14th Circuit erred in not admitting the translation.
Well, here's my question for you about that. I mean, what about the respondent's point about the difficulties in translating this particular language? I mean, it's not as though the translator is some inanimate object. It's a person, and the points that they make are the language point. And what if the interpreter has some kind of an axe to grind?
Well, Your Honor, in some sense, they are a mere conduit. The original speaker, here Ms. Spector, speaks, and then Eric Moltz translates for her. And in the sense of whether or not they have an axe to grind, the four factors do adequately assess that. The third factor specifically assesses.
But how do we know that in this case? Because nobody knows where the person is.
Well, if Mr. Moltz had translated in a way that was inconsistent with what Ms. Spector said, or if he translated in a way.
Doesn't she claim, or her lawyer claim on her behalf, that there are some inconsistencies or ambiguities?
Well, that's what respondent claims, but petitioner's contention is that, as demonstrated on page 19 through 20 of the record, these are not inconsistent. On the one hand, she says, I am the CEO, I selected the charities. And then on the other, she says there's not a fact that slipped by us. It's entirely possible for her to have had a team that helped her select the charities, but also for her to have been responsible for using her position as the CEO to divert the funds. So they're not incompatible, they're not inconsistent.
You seem to be suggesting that's in terms of testing accuracy, in terms of the pronouns and that. What about the fact that how do we know she even said the content of it at all? Because the translator is not there.
Well, Your Honor, we know that this is what she said because without the Mr. Moltz would not.
This is what the interpreter said she said, right?
Well, Your Honor, to some extent, the interpreter would have never had the ability to make these statements without Ms. Spector.
But what if the point is, what if he's a really bad interpreter and is getting it all wrong? I mean, there's no way to tell, right? Because all we have is the transcript of the statements, and if he's really bad at it, there's no way to tell.
Well, applying the four factors, there is a way to tell because they specifically assess on a case-by-case basis whether or not it's fair to infer an agency relationship between the translator and the original speaker.
Is this translator certified as, what is the nature of that certification?
Your Honor, as demonstrated on page 27 of the record, he took an oath prior to actually translating, and as demonstrated on page 13, he's employed by Boreum certified translators and is fluent in both Remzi and English translation.
But you say Boreum certified translators. Who certifies?
Well, the translation agency itself, and as demonstrated, he does speak both of these languages fluently.
I mean, this is not that he passed a government test or something like that.
Your Honor, I believe he is state certified, and that's why the four-factor test is particularly probative in this case, because it does adequately assess whether or not the statements are those of Mr. Moltz as a rogue interpreter or those of actually Ms. Spector. And actually going to my second point, which is that the language conduit theory is applicable in this case because he's not offering testimony against her. Applying the four factors, it's clear that they slide in favor of the government.
Would your position be different if the agent didn't write down the translation but remembered it, and if trial is going to testify as to what the memory is of what was it translated said, she said? Would it be different? Your argument would be different?
Yes, Your Honor, because on that respect, it wouldn't be a present sense impression of what the interpreter said, and that was being immediately written down by the actual
It wouldn't be a
agent.
question of present sense. He was there, and that's what the translator said, she said, and he remembers it verbatim. I mean, to the extent he can. Why would that be, it's not present, sense of that. Would it be any different?
Well, the notes themselves do qualify as a present sense impression exception to the rule against hearsay because they were being made simultaneously when the translator spoke, and then they were being written down by the actual agent in this case. So they are substantially verbatim. They are essentially what Mr. Moltz said as Ms. Spector was speaking. So in that sense, he is a pure conduit for her. Respondent's position is that this violates Bullcoming. But in the case of both Bullcoming and Melendez-Diaz, those analysts were offering something against the defendant. They were offering a cocaine sample. They were offering a blood alcohol level. Here, Mr. Moltz is not offering anything other than Ms. Spector's own words.
Well, what he is interpreting her words to be. It's not actually her words, is it? Her words were in some other language.
Yes, Your Honor, that's correct. So to some extent, there is a degree of variation, but he is a conduit for her. He's not saying anything separately from what she said. And
Would your position be different if there were an affidavit from someone else fluent in the language taking issue with the translation, or I don't know what else, an affidavit from somebody who was present saying they thought the translation was wrong?
Well, Your Honor, actually on page 21 of the record, page 17 of the record, there is such a description of it being erroneous or that translation is subject to error or that it's subjective. So
Was
Ms.
that by somebody who was there?
No, Your Honor, it's not by someone that was there, but just an expert in the field of linguistics. So there's nothing preventing Ms. Spector from saying, providing an expert saying the translation is unreliable, it should not be given a lot of assessment by the jury. But what she cannot do is claim a constitutional right to confront someone when it's her own words. And
Well,
that,
that's the question, isn't it? Whether it's her own words or not?
that's correct, Your Honor. And the petitioner's contention is that it is her words. It's her words through Mr. Moltz. He was a mere conduit.
I think the difficulty with this is because when we think of a conduit, we think of someone who has absolutely no control over what happens. It's just as though the words go from her mouth through him automatically. But we all know that's not true. So if as I said, there are so many factors that if he's making a mistake, or there's a theory that he's got some stake in the outcome of this based on some interest in whatever is happening in the country, those are real issues to consider. Don't you agree?
Absolutely, Your Honor.
And so how would the four-prong test, how would that reassure the court that this is something that we don't have to worry about?
Certainly, Your Honor, and this takes me to my second point. In United States v. Ormheim, the Ninth Circuit recently found in 2012 that the language conduit theory doesn't violate the Confrontation Clause because the four factors do accurately assess any biases or unreliability of the translation. Those four factors are, first, the party that selected the interpreter. Second, whether the interpreter had sufficient qualification. Third, the interpreter's motive to mislead or distort the actual translation. And fourth, whether actions taken subsequent to the translation are consistent with the statements translated. With regards to the first factor, it is relatively undisputed on page 13 that the government, in some effect, provided Mr. Moltz to Ms. Spector. They did use an independent agency, Boreum Certified Translators, but they were the ones that did provide Mr. Moltz to Ms. Spector as a convenience. However, the lower courts that have assessed this problem find that that fact's not dispositive. They look more to see if an interpreter is actively involved in the interpretation, meaning that interpreter is both the agent and the interpreter. So it would be an entirely separate case from this because there was Agent Malone present and there was also Mr. Moltz and Ms. Spector.
I'm sorry, I'm not sure I understand what you mean by actively involved. Could you?
Certainly, Your Honor. Essentially, it would be where the interpreter is both asking the questions and interpreting those questions at the same time. So there's no third party that's serving as a neutral interpreter. And that's what the courts, at least the Fourth and Ninth Circuits, have found is particularly dispositive. And that's not what happened here. Mr. Moltz was just sitting there, acting as a way for Ms. Spector to share her story. Turning to the second factor, which is
I just want to make sure that I understand. He interpreted what the questioner was asking, correct?
That's correct.
And then interpreted what she said back, also correct?
That's correct, Your Honor. The
But you
se-
do know that that first point doesn't turn your way because your explanation, those circumstances, at best, is neutral, correct?
Certainly, Your Honor, and
All
even
right.
if this court finds isn't satisfied, the second factor, the sufficiency of the qualification, is particularly dispositive in this case. There is no dispute that Mr. Moltz was qualified to speak both
They've been working there
Remzi.
2 months, correct?
That's correct, Your Honor.
That's not what you call long in the tooth on the job, is it?
Well, he might not have been working for a long time, but he certainly was qualified. He took an oath, he spoke both languages, and so he was sufficiently qualified.
Those are the minimum requirements. You speak both languages and you took an oath.
Well, the Ninth Circuit has found that those are qualifications, that does make someone sufficiently qualified if they are both certified in the language by such an agency as Borum Certified Translators.
Is he a native of what is it, Remsen?
Remsen, yes, ma'am. Yes, he was a native of Remsen. And this is turning to the third factor, what Ms. Spector latches onto to say that he was biased or had motive to mislead or distort, by saying that he was forced to flee Remsen because of pressure he felt from the terrorist organization that she's accused of diverting funds to. However, recently, the Fourth Circuit has found in United States versus Zhu that what's more dispositive is actual evidence. As demonstrated on page 19 through 20 of the record, he translated in a way that was very favorable to her, casting her as someone who just wanted to help the people of Remsen, didn't want to cause them any harm. In fact, she's quoted as saying, I just wanted to help. That's not someone that's trying to mislead or distort a translation or has an axe to grind with the actual original speaker.
What about the last factor?
The last factor is whether actions taken subsequent to the translation are consistent with the statements translated. And here, Ms. Spector continued to rely on Mr. Moltz. She didn't say, that's not what I said, and in an addendum to the record, it's clear that she speaks English well enough to understand it. And what's more is she's a CEO of a multinational bank. She is operating in a primary English-speaking place, and so she certainly must speak English well enough to understand when someone's attributing words to her that she herself did not say. But despite that, she continued to rely on Mr. Moltz and continued to rely on his translations.
What do you mean by that? You mean during the statement?
That's correct, Your Honor, because what he translated was said in English, and she could have certainly said, that's not what I said. I didn't say that. And so that shows acquiescence. That shows an agency relationship, which means that the Federal Rule of Evidence 801D2, agency admissions or authorized admissions, is met in this case. And these should be attributed to Ms. Spector because they are the words that she said through Mr. Moltz. And as such, he's not offering testimony against her in the...
I thought it was conduct that we look at, subsequent conduct.
Your Honor, in what respect?
Well, you said that the conduct after the translation, you say is consistent with it being true. Was that conduct because she didn't say anything about it?
Well, Your Honor, I see my time has elapsed. May I answer your question?
Yes.
The subsequent conduct would be after the interview. She could have immediately after said, I didn't make those statements. Instead, she sat the entire interview and said nothing.
But I thought we assessed conduct. You said we should assess the absence of conduct.
Well, Your Honor, remaining silent is a degree of conduct.
Oh, it is?
Yes. That's the government's
Maybe
position.
we'll hear more about that later.
Yes, Your Honor, you will from my co-counsel. So thank you so much.
Thank you, counsel.
Mr. Chief Justice, and may it please the Court, my name is Gabriela Gallego, co-counsel for petitioner, the United States government. The Fifth Amendment cannot be improperly expanded to implicate the privilege against self-incrimination both when the United States government was unequivocally uninvolved or when law enforcement was simply following this court's precedents under Miranda versus Arizona. Accordingly, petitioner respectfully requests that this court reverse the 14th Circuit and hold that Ms. Spector's Fifth Amendment rights were not violated for two main reasons. First, the Fifth Amendment only bars the use of compelled testimony when the compelling authority and the using authority are both bound by the Constitution, or when the using authority collaborates with the compelling authority.
So
Why should that be? I mean, the Second Circuit thought otherwise, didn't they?
That's correct, Your Honor, but the Second Circuit not only erred in its analysis, but its facts are indistinguishable to the case before us. The Second Circuit there, the United Kingdom was collaborating
Yeah,
with...
I understand that the facts are distinguishable, but assume they weren't.
Your Honor, the Second Circuit relied entirely on this court's holding in United States versus Bram. However, Bram addressed whether or not a confession was given voluntarily, whether or not there was coercion. And as this court stated in Colorado versus Connolly, that is a modern analysis of the due process clause.
Well, let me try my question a little differently. I'm not as interested in what Bram meant or what Allen meant as I am in whether the purposes of the Fifth Amendment guarantee against compelled self-incrimination are implicated here.
Well-
So can you tell me why it isn't the case that the introduction of this statement would would compel her to be a witness against herself?
Your Honor, the Fifth Amendment is not implicated here because the Remsen government is not bound by the Constitution, and it is only
But
at
under
the
that, but under that analysis, sorry to interrupt you, but under that analysis, you know, you could violate all kinds of rights and say, oh, you know, not our Constitution, it doesn't matter. You're not saying that, are you?
No, Your Honor. If the FBI had been involved, or if they
But let's
had-
say they're not involved. Let's say they've got nothing to do with it, but it violates our Constitution. Is it your position that the government could use a statement that violates our Constitution in some other way, in some, you know, they didn't let the lawyer in, something like that? Not our Constitution, you know, they're not bound by it. Are we allowed, should our government be allowed to use it?
No, Your Honor. If Ms. Spector had been physically coerced or had given this involuntarily, then that would be a due process analysis, and as such, this court would not allow it in. But as the record notes on page 35, Ms. Spector was not physically coerced, and she gave this interview voluntarily, and as such, it is
I
admissible
thought it was
here.
compelled. I thought it was legally compelled testimony.
Your Honor is correct that it was lawfully compelled while Ms. Spector's attorney was present, but Ms. Spector concedes that she did not give it involuntarily, and that's what Bram looked at.
I'm sorry, I don't understand. How was it compelled and yet voluntary?
Well, Your Honor, that looks to whether or not there was a sense of coercion, and here there was none. And
Well, how was it compelled?
it was compelled because she was given under threat of contempt.
And what would happen under, so let's say she decided, I'm not going to give this statement, then what happens to her?
Well, Your Honor, as the record reflects, she would not have been allowed to return to her home in Borum, and she would have, it was under contempt, so it likely would have been.
And you're saying that's
imprisoned.
not coercive?
Well, Your Honor, not coercive in the meanings of how the 14th Circuit uses Bram and how the 14th Circuit analyzes it and ignores the same sovereign principle. Here, the FBI was entirely uninvolved. If the FBI had in any way colluded with the Remsen government, then that would be an entirely different situation. But that's not what we have here. Instead, here we have a vast expansion of the privilege against self-incrimination. Here we have a holding that actions taken by not only a Remsen government, but a terrorist group implicates the United States Constitution. And that cannot be, because as Justice Stevens noted in the United States versus BLS, is that this would undermine how the FBI investigates and prosecutes terrorists.
How?
Well, Your Honor, because that if this court adopts the 14th Circuit's holding, then a Castigar hearing was correctly held, and Castigar hearings are incredibly burdensome. They make the FBI.
Are you saying they're impossible or just they're expensive?
No, Your Honor. I'm saying that they're burdensome and unnecessary when the United States government was not involved. They did not give Ms. Spector
Well,
any...
maybe a little bit of burden is an appropriate step to take to guarantee somebody's constitutional rights. What about that?
Well, that's true, Your Honor, and this case doesn't come down to a burden or not. The government did perform the Castigar hearing, but this court it comes down to what the Constitution applies to, and it applies to the United States government,
No,
not
it
to...
applies to persons who are charged with crimes and whether or not we're going to use their compelled testimony against them. At that juncture is where the right is perfected or not perfected. Is that correct?
That's correct, Your Honor, but at the time Ms. Spector gave that interrogation or submitted to it, she did not have an indictment at the
That's
time.
the whole point. How is upstream activity, right or wrong, enough to surmount the obligation under the Constitution to make sure that compelled testimony is not introduced against the person?
Well, Your Honor, it comes down to whether or not she had this immunity. Yes, her testimony was compelled, but it's the actions of the DRB that millions of people saw this recording. It would be virtually impossible for the FBI to develop evidence without having any of his witnesses view the recording.
So you're talking now about the consequences of the publication of the statement, right? I think the trouble that we're having is how to protect the values of our Constitution when we're talking about a statement that's made under circumstances that don't have our constitutional guarantees. I think that's the difficulty. At least it is for me.
Petitioner does not contend that Ms. Spector's Fifth Amendment rights go out the window the moment she steps outside of the United States, but it is the fact that this court has never held that the privilege against self-incrimination applies to a compelled testimony from a foreign sovereign.
Don't you have an argument that the foreign sovereign should be treated the same way as a private employer?
No, Your Honor, because private employers likewise don't implicate the
Yes,
privilege against...
that's what I was suggesting, that it is not the case that all compelled statements, all coerced statements, are excluded from evidence by the Fifth Amendment, right?
Correct, Your Honor.
And so does the question become, is a foreign sovereign for this purpose like a private employer, or is it like the United States?
Well, Your Honor, the 14th Circuit attempts to argue that the source of compulsion is irrelevant. So whether it's a private employer or a foreign government, that compelled testimony cannot be used.
Is that the rule?
No, Your Honor. Private employers do not implicate whether or not compelled testimony can come in. That would mean that if you were to sit down for a job interview and any testimony or any statements you made were given, that could be used in a criminal trial. But that's not how the Constitution works. The Constitution only bounds the United States government. And when they have not acted in any way to collude with the source of compulsion, then the privilege against self-incrimination does not apply. Turning to my second issue. The 14th Circuit erred when it found the defendant's pre-Miranda custodial silence inadmissible under the Fifth Amendment. Because as this court held in Salinas v. Texas, before a suspect can rely on the privilege against self-incrimination, it must unambiguously invoke it.
What is the evidentiary argument for admitting an agent saying something pretty inflammatory and the defendant saying nothing?
Your Honor,
What's the, I don't quite understand that. It's a statement made by this agent that you're the worst person who ever breathed air and you don't have any right to live here, and she says nothing. How is that admissible?
Your Honor, the government intends to use admission of this evidence under Federal Rules of Evidence 801 D2B as an adopted admission to prove guilt. That in response to the law enforcement agents that she was guilty of funneling money to terrorists, that she remained silent, and as such, she adopted this statement for its truth. That's
Now,
what...
if we don't find that persuasive, does that make the constitutional question moot, essentially? That is, if we don't think it has any evidentiary value?
No, Your Honor, the evidence could still come in, but that's...
Even if it has no evidentiary value?
sorry, Your Honor, I misspoke. That if it had, of course, if it had no evidentiary value, then it's not relevant, and no irrelevant evidence should come in. But it is relevant, Your Honors. Here we have a investigatory measure taken on behalf of the FBI. Not everything said on behalf of law enforcement agents is meant to be an interrogation.
You
Instead,
don't think that's likely to prompt some kind of a response, an accusation like that? I mean, you're saying that's not the functional equivalent of interrogation?
correct, Your Honor. That's what this court defined in Rhode Island versus Innis, where the functional equivalent is defined as any actions or words taken on behalf of law enforcement that are reasonably likely to elicit an incriminatory
How is
response.
this not likely to, forget about just any response? I don't, can you explain that to me?
Well, Your Honor, it is an incriminatory response that defines the functional equivalent, but yes, I will explain. Here, so in Innis, this court, there was one suspect in the back of the law enforcement's car, and one cop said to the other, oh, it would be a shame if a little girl were to find this gun, and I don't know, maybe kill herself. This court held that such statements did not arise to the level of direct compulsion to speak. That's what this court needs to look at, whether or not Ms. Spector was compelled to speak. And here she was not. Yes, the statements were angry and they were emotional, but they did not directly compel Ms. Spector to speak. And
No,
thus,
I think not only did they not compel her to speak, but her failure to speak carries no weight. I think you're so right that you've just talked yourself out of relevance.
well, Your Honor, respectfully, that's for the jury to determine, because it is their role as the fact finder to weigh the evidence and determine the credibility of the actions that Ms. Spector took at the time of her arrest.
But in this case, counsel, not only was it accusatory, but it was condemnation. You should be ashamed of yourself as much as this country has done for you, the life you have here. It's on steroids, isn't it, in terms of statements? Is it not?
Your Honor, petitioner recognizes that this is a difficult situation, but it really comes
It's
down.
actually not, though, because I'm just trying to think of how a jury is going to interpret this. This FBI agent just reams her out. You're the worst, you're a terrible person, you're taking advantage of our country, and she doesn't say anything. I mean, I know that's not really the point of your argument, but I'm having a hard time seeing how that comes into evidence.
Your Honor,
Is it your position that anybody else would have said, no, I'm not a terrible person?
well, Your Honor, we don't look to what the subjective knowledge of a defendant or a suspect may think at the time.
But that's why you're offering the statement, right? I think your position is that the fact that she didn't say anything means that that she agrees that she is in fact a terrible person. So that's why you're offering it, right?
Yes, Your Honor, that is an adopted admission.
Okay. All right, go ahead.
However, this court could look to a comment for the adopted admission, where the evidence committee stated that maybe silence does implicate privilege against self-incrimination issues, but any issue has been resolved by this court's jurisprudence, and specifically that silence is only prohibited in two instances. One, when the Miranda warnings have been read, or two, when they are expressly invoked. And here we don't have that, Your Honors. Ms. Spector did not invoke the right to remain silent at the time, and thus that evidence is admissible. And two, the Miranda warnings had not been read, and that's why we don't look to the subjective knowledge of a suspect.
Was she in custody?
Yes, Your Honor, as seen on page 3 of the record, she was in custody. But that's where the 14th Circuit erred in holding that custody was the triggering mechanism for the right to remain silent. That's what this court rejected in Weir versus Fletcher, that it was not. An arrest by itself is not governmental action that induces the defendant to remain silent. Instead, what we have here is an instance where the suspect did not invoke her rights, as is required by this court's holding in Burgess versus Tompkins. And as such, there was no Fifth Amendment implications in the using of this evidence. And thus, it is admissible under the adopted admission. And it's for the jury to determine the credibility of Ms. Spector, because her Fifth Amendment rights are not implicated here.
The question isn't the credibility of her, it's the meaning of her silence, right?
Yes, Your Honor. The job for the fact finder is to weigh the evidence and to weigh what this silence means. Your Honors, we need to draw a line here. Because there is ambiguity, I see my time has elapsed. May I briefly conclude?
Yes, very briefly.
Your Honors. Because there is ambiguity, that's why this court requires suspects to unambiguously invoke that right to remain silent. Thank you.
Thank
Thank
you.
you.
Mr. Chief Justice, may it please the court. My name is Tom Morris, and along with my co-counsel, Mr. Alex Stout, I represent the respondent, Victoria Spector. Mr. Stout will be explaining why the 14th Circuit was correct, or excuse me, I will explain why the 14th Circuit was correct in holding that Ms. Spector has a right to confront the testimonial declarant Eric Maltz, while Mr. Stout will be explaining why the 14th Circuit was correct with regards to the Fifth Amendment.
Let me ask you, let's say you have the interpreter. You've got him here. What are you going to ask him?
Myriad of things, Your Honor. For example, why are there inconsistencies in the translation, such as I versus we?
What if he says they're not? What are you going to do to, what good is having him there going to do to you?
Your Honor, because it gives the possibility, and even if it's an ineffective cross-examination, that's never been the test under this court's precedent. In Crawford v. Washington, Justice Scalia wrote in the opinion that it is not the guarantee to an effective cross-examination, but rather the right to cross-examine. That crucible of cross-examination is the only thing which can satisfy the confrontation clause. And that confrontation clause is triggered in one circumstance, when there's a testimonial declaration which is made out of court with the witness not having a prior opportunity to cross-examine that witness.
What's the comparison between the earlier statement that was broadcast all over the country and this statement through the interpreter? Are they similar?
Your Honor, the statement which was made through the interpreter was actually prior to the statement which was broadcast. That occurred in June of 2014, as is found on page 13 of the record.
And are they consistent?
Your Honor, the consistency is not a relevant consideration here.
I'm just asking, are they?
Not necessarily, Your Honor, no. And again, it goes into that distinction between the I versus we. Because the one is an inculpatory phrase, whereas I am responsible, I select this charity, I am responsible for any money which goes to this, which goes to fund this terrorist organization.
I have one other question for you on this then. So if you're right and the interpreter is more than a conduit, does that also mean when you have an interpreter at trial that you can call that interpreter as a witness to cross-examine to make sure the interpreter is translating correctly?
Your Honor, in that situation, it would be slightly different because the interpreter is actually at trial and there's a guaranteed transcript of the record there in a court proceeding.
How do you know he's translating it correctly? Unless you speak the language, right?
It's correct, Your Honor. However, and if there was an issue at that point, then the appropriate remedy would be, because it takes place in a court proceeding, it might be to raise a cross-examination issue, yes, if there's an allegation that the testimony is false. However, in that case, when we have, for example, here in federal court, when there is a certified language translator, that translator is certified on the national level through the federal procedures which are set out. And one of the fruitful grounds of cross-examination would be what exactly is entailed in the certification process with Mr. Maltz underwent. We know that he swore an oath, and we know that he was certified by the state of Borum. What that certification entails is unclear in the record.
Can't you call a witness to say all those things?
Potentially, Your Honor, but to call a secondary witness to testify about the qualifications of the translator itself.
What if he was dead? What if the translator's dead? Nobody's fault.
In this case, Your Honor, we're not claiming that it's the government's fault, but it's the same result.
But what would so you're saying if the person dies, there's no other way that you have to get this evidence in that maybe the translation wasn't right?
Yes, Your Honor. Unfortunately, the confrontation clause does not have an expiration date simply because the witness expires.
What about your client? Did she ever say, hey, he's not translating that correctly?
No, she didn't, Your Honor. And this is where there's some inconsistency on the government's part. Because at the time, the FBI provided the interpreter for Ms. Spector. Ms. Spector did not request the interpreter. And so the FBI thought that Ms. Spector needed the interpreter in order to conduct this interrogation. Yet now they also claim that she was fluent enough in English and understanding the language and the context enough to be able to correct the interpreter.
Which is true. She's your client, right? Does she speak English?
She does speak English, Your Honor. However, the record is silent as to how fluently she speaks English.
Well,
And
do you know how fluently she speaks English?
Unfortunately, I'm unaware of that, Your Honor. I was not the counsel at trial. And so,
And you haven't ever spoken to her?
no, Your Honor.
If
I
this
have
were
not.
if this were videotaped, this wouldn't be a problem, right?
Correct, Your Honor. If
And who asked that it not be videotaped? in
Ms.
this case?
Spector did request that it was not recorded. However, it's unclear whether or not the FBI, how hard they pushed for that, or whether the FBI informed Ms. Spector as to the potential consequences of that.
You think the FBI should have, when she said, please don't record this, you think the FBI should have said, well, you probably should record this because maybe we won't be able to have the interpreter available?
Absolutely, Your Honor, yes, because it informs Ms. Spector that the witness against her, the testimonial declarant, who is giving meaning to the words, because she is translating the words from Remsi, which is a particularly difficult language to translate, giving them meaning in English and putting them forth in that language, and therefore is a testimonial declarant. And because of that, she has the right to cross-examine them. She has the right of confrontation, which is fully in line with all this court's precedent.
You take the position should be per se, there's a translator involved, you're entitled to the translator being present in all cases?
Yes, Your Honor. That result is compelled by this court's decision both in Crawford v. Washington, in Cumming v. New Mexico, and in 2015 in Ohio v. Clark.
But Crawford against Wyatt, that dealt with testimonial, actual testimony by people that were testing, that were going to be testifying for the government against the defendant. That's not what a court interpreter does.
That's exactly the purpose of it here, Your Honor.
A court
And-
interpreter is a witness against the defendant? That's why the government brings them in?
In this case, Your Honor, that is exactly what happened here, and it goes back to this court's decision in Ohio v. Clark, where the totality of the circumstances need to be evaluated. When the totality reveals that the purpose of the conversation was to foster and facilitate a criminal prosecution, that makes the conversation testimonial, and they are testimonial declarant.
Yeah,
Let
but
me ask you a question. Suppose there were a Google Translator version of her statement, an algorithm. Your brief says this isn't an algorithm, but suppose there were, and that were offered in evidence. Would you be claiming you have a right to cross-examine who? The person who, well, who?
Whoever certifies that translation and that algorithm as correct. In that sense, Your Honor, it would be very similar and analogous to Cumming v. New Mexico, where the point was not that the lab result itself was what was at issue, but rather the certification from the lab technician that the process and the lab results were done correctly. And that is what would raise the result of cross-examination.
But that's different, though. That's in the alchemy of the forensic lab. But this wasn't in the alchemy of that. Your client is sitting there
And it's
at the time that the stew was made. And could have said, there are no potatoes in here. And I said potatoes.
That's true, Your Honor.
Why not? So you're trying to now take this on to some lab where she's not there at the elbow. That's not this case.
No, Your Honor. In fact, this case is more egregious because in that case, there's
Egregious?
scientific certainty with the lab results, and yet even then, this court has always required the technician, even with the scientific certainty of a lab, to require that technician to be present. Here, we have a highly subjective language, which the interpretation depends largely on the individual background and path of the
So
the
I know
interpreter.
you're going to tell me that the right to confrontation doesn't guarantee a good cross-examination, but I'm still trying to envision how this cross happens. You have the translator, and he says, she said this, and what do you say? No, she didn't? I mean, none of your jurors are going to speak the language, so there has to be a point to cross-examining the translator. So if there's no way to establish your point through the interpreter, why should we add a whole new layer of complexity to criminal trials?
Your Honor, there's many different ways to do it. For one would be to ask, why did you interpret this? Not necessarily is that wrong, but why did you choose to use the word I and the word we within the same
And he'll say,
sentence?
because that's what she said.
Well, Your Honor, and that may be the case, but again.
But
if
why
we're-
my point is, why do you need him for that? Because you've submitted all these other things that show that you can make your point. The person who says this is a very complicated language. You have evidence that he was only certified for 2 months. So the guarantee of constitutional rights also means that if we're going to impose this requirement for criminal trials, there should be a reason for it. And what I'm trying to figure out is, how does having that person sitting in that chair advance the ball for you?
Your Honor, because it's much more persuasive to have the interpreter get up on the stand and say, this is a difficult language to translate.
So is your theory that you could cross-examine, or someone could cross-examine him and he would admit that, right on the stand there, that he got it all wrong? Is that your theory?
No, Your Honor, but he would at least admit to the jury that Remsey is a highly contextual language, that while there is both a personal and a plural personal pronoun in English.
Get your expert to say that. Call that guy, the person who said how complicated it was.
And yet again, Your Honor, that falls us right back into the case of Bullcoming, which this court rejected because it is much more persuasive.
No, it's completely different because you want somebody to say this language is difficult. That doesn't have to come from the person who did the interpretation.
No, but it's more persuasive when it comes from the man who's claiming that his interpretations are accurate. And that's the other fruitful ground, because that is the implied assertion which the 11th Circuit found in United States v. Corbello that every interpreter gives, that there's an implied certification that this interpretation is an accurate representation of what was said by Ms. Spector. And if that's the case, then that's also fruitful grounds for cross-examination. Why do you feel this was certified? Why do you feel this? And that is what places it directly in line with Bullcoming.
But at the end of the day, if you had cross-examination, wouldn't it come down to weight as opposed to admissibility?
Yes, Your Honor, it would come down to the weight of the evidence, and that's why the need for cross-examination is so important. There's no way to effectively argue the weight without having this right guaranteed to her.
Well, I think that's what my learned colleague, Justice, said to you, because isn't it better to have someone else to say how terrible it was than to have the person come there and just confirm how good I was?
Well, we don't know exactly what would actually come out in cross-examination,
I
but
don't think that's much peradventure to think that he would come and say, oh, I did a great job.
well, of course not. Your Honor. We don't expect him to say that I was wrong here, but for him to be able to admit that there is some doubt and there is context which goes into the translation, that's the purpose of it there.
So-
and that would be reinforced by the expert witness.
Every criminal trial that involves some kind of an interpretation then is going to have a whole new layer of argument about whether, you were using the subjunctive or you were using the future imperfect. And that gets us far away from the point of what the trial is. And I'm having a hard time seeing what the value is to doing that in a case like this, when you have told us all the other means you have to show that there might be some flaws in this interpretation.
And yet this court has always required those same means to not be
But
insufficient
we're
to
asking you
satisfy.
why we should apply that rule here. It's not enough to tell us that we've always done it before, is it?
No, Your Honor. While its precedent is highly persuasive, this court is not bound by it. But the distinction is because, again, it serves the purpose of the Sixth Amendment right, because it allows the defendant to actually confront the person who is saying, this is what you said. This is why I believe this is what you said. This is why I think this is an accurate representation of you accepting guilt for a criminal action.
What are the odds that this interpreter, how many years ago did this happen?
This happened in 2014.
You think he's going to remember exactly what she said? And again, it's a practical concern that injecting a whole new layer of requirements into a criminal case, there should be some value from doing that.
Well, yet another value in this case, Your Honor, would be that the only record we have of what was actually said, and there is not Mr. Moltz's own writing and writing down of what he translated, but rather what the FBI agent recorded.
And
as
why
Mr.
was
Moltz
that
said.
again, that we don't have a record of it?
There's no audio recording because of what
Because?
Ms. Spector, Your Honor. However, there was nothing which prohibited Mr. Moltz from writing down and certifying, this is what I said. Instead, we have the FBI agent's record saying this is substantially verbatim what Mr. Moltz said. What substantially verbatim means is open to questions.
Can you cross-examine the FBI agent?
We can, Your Honor, but again, of course, the FBI agent is going to the same situation as Mr. Moltz. I wrote down what he said.
So no point, right?
But asking Mr. Moltz, is this what you said, is a separate area, Your Honor.
Yes.
And but Your Honor, while that's a risk, that's the truth for every single witness. Every witness on cross-examination is going to say, yes, I'm right. Any FBI agent in any criminal prosecution, yes, I followed the Miranda rules. Yes, I did this. And yet this court is still always guaranteed the Sixth Amendment rights because it is the right to confront the one who's accusing you. Because of those reasons, Your Honor, because the interpreter is a testimonial declarant, this court should affirm its ruling and affirm the ruling of the 14th Circuit. Thank you.
Thank you.
Thank you, counsel.
Mr. Chief Justice, and may it please the court, my name is Alex Stout, and I also represent the respondent, Ms. Victoria Spector. Your Honors, this court should affirm the holdings of the 14th Circuit regarding the Fifth Amendment for two primary reasons. First, because the right against self-incrimination is implicated even when statements are compelled by foreign officials. And second, because the prosecution may not use in its case in chief the fact that a defendant stood mute in the face of an accusation post-arrest. To my first point, Your Honors, in United States v. Abu Ali from the Fourth Circuit in 2008, the court held that even though the defendant had conceded, and that's on page 228 of that opinion, that the FBI was not involved in the questioning or procuring a written confession from the Saudi officials, that even then the standard of voluntariness applied to the statements and to the written confession, and thus only because it passed that test was it admissible at trial.
What about your opponent's point that if we rule your way, that just encourages foreign governments who might want to interfere in the FBI's investigation of a particular matter to do precisely what happened here, to question the defendant and then release the video, secure in the knowledge that we'll rule that there's no that the investigation hasn't been tainted by the video?
That's a possibility, Your Honor. However, the circuits in this area are unanimous and are consistent with this court's decision in Bram versus United States.
From how long ago?
From 1897, Your Honor, to 121 years of uncontroverted United States Supreme Court precedent. That case has been upheld and is still cited even to this day, as recently as last year in the Second Circuit's
Okay,
decision.
let me ask you this question I asked your adversary. Is it your position that the same rule applies to a private employer or someone else who coerces testimony? And if not, why is there a difference between a foreign sovereign and a private person?
No, Your Honor. Our contention is not to extend this court's ruling in this case to overrule United States versus Solomon and hold that private citizens are governed by this
But
clause.
why is that? Why is there a difference? Presumably the reason the private citizen's coercion doesn't count is that the private citizen's behavior is not what the Constitution protects against. And why isn't that also true that the Constitution doesn't protect against what other countries do?
Well, Your Honor, it's not so much that the Constitution protects against what other countries do, but rather that the Fifth Amendment is, as the 14th Circuit pointed out, a trial right, and it uses the word witness. A person shall not be compelled.
It's partly a trial right. It's a right not to have used at trial something that was
Unlawfully
coerced in a
compelled.
certain way, but apparently not all coercion counts, because private coercion doesn't count, right?
And that's true, Your Honor, and that's why, once again, we're not asking this court to extend this to overrule
Well,
Solomon.
so what makes the sense of the difference?
Because there are different incentives to preventing a private citizen from engaging in this conduct. For instance, if a private citizen were to hold a gun to a person's head, that would most likely be criminal and tortious conduct.
what if
How about
I'm
if they
gonna
just said,
fire
I'm
you?
going to fire you?
Well, Your Honor, in that case, it wouldn't necessarily be coercion, because that would be a different standard under the Due Process Clause of the Fifth Amendment. That would probably be more like compulsion, which is what we have in this case. But still, the facts of this case don't implicate that, and the difference is, once again, that a private citizen is not bound by the Constitution.
Neither is a foreign country.
No, Your Honor, but the FBI is, and when there's government coercion, and this was lawful coercion under the laws of Remsen, and because of that, they were using the coercive power of the government, which is exactly the type of situation that the Constitution was
No, the
intended to prevent.
Constitution wasn't concerned with the coercive power of another government, as far as I can tell.
Well,
It was
you're-
concerned with what happens here.
Well, Your Honor, in Bram versus United States, this court held that even when a Canadian investigator acted unilaterally to go onto a ship flying a flag of the United States where he had absolutely no jurisdiction, dragged the defendant off of the ship and subjected him to a compelled interrogation after strip searching him, that the
Well,
Constitution...
tell me why that makes sense, because it's up to us now to figure out what the Constitution means in this context, and I'm just having trouble understanding why.
It makes sense because of the inherent coercive power that governments hold instead of private citizens. Once again, governments have the ability to throw people in prison, and that's exactly what Ms. Spector was subjected to. It's on
She
page.
was in prison?
She was threatened with contempt of court, Your Honor, and that's on page 31 of the record, that she would have been held in contempt had she not answered the
Does it
questions.
say she would go to jail?
Yes, Your Honor. And because of that, another distinction is that the government actually misstates the standard. This is not a coercion issue, and involuntariness is the same thing as a compelled statement. And involuntariness is the standard under the self-incrimination clause. We're not bringing a due process coercion, shock the conscience argument to this court today.
Do you think it's relevant here that this country was unstable and may not qualify as even foreign, notwithstanding foreign, even government?
Your Honor, it's not necessarily relevant because the issue is whether or not under a foreign government's compelled statements laws that the evidence could be admitted at trial here in the United States.
So if instead of being a foreign government, it were foreign pirates, it would be a different result?
It would be, Your Honor, because that would be without the coercive authority of the government and without the...
You haven't seen pirates raid a ship, have you?
Yes, Your Honor.
It's pretty
Yeah,
coercive.
I don't think that's your strongest argument.
It is coercive, Your Honor, but it's not under the color of law, and that's the issue, is that the Remsen officials were acting under the color of law.
But that doesn't make any sense. It doesn't make any practical sense because our rules have to make some sense, I think. And if it's okay for a private citizen to do all kinds of things and not have any impact on it, on the admissibility, then what's the difference between a government that's completely unconnected to this one? FBI has no involvement whatsoever. There's no collusion of any kind, if I can use that word. And so what's the difference between, I think that's what we're trying to figure out, what's the difference between those situations as a practical matter?
And the difference is, Your Honor, it incentivizes the United States to be deliberately indifferent to the rights of people who might be brought under prosecution here if they travel overseas. The Constitution
How does it do that?
Because, Your Honor, if, for example, the FBI, which we concede they weren't aware in this case, but a ruling in their favor, in the government's favor, would incentivize them to simply...
Why don't we wait for that case then?
Well, Your Honor, because there could be potential constitutional violations that are occurring, and people wouldn't be protected the way they ought to be if the government is blinding themselves to potential constitutional violations and throwing up their hands and saying, we didn't do anything.
We can recognize a case like that when it comes along. We don't have to decide that case here.
That's true, Your Honor. It's not the facts of this case. However, it creates the potential and a policy interest why this court should rule in Ms. Spector's favor in this case, because we don't want future defendants to have their constitutional rights violated either, and certainly this case is going to have precedential value moving forward. And it is important to note, once again, the circuits are unanimous on this point. The 2nd, 4th, 5th, 9th, and 10th circuits all agree with Ms. Spector's position that even when
That's only half the circuits, right?
Yes, Your Honor, but they're the only circuits that have answered the question, except, of course, the Court of Military Appeals also answered the question and once again found that voluntariness is the proper standard, and it flows directly from this court's uncontroverted decision all the way back in 1897 in Bram. And because of that, it's improper to overturn the overwhelming weight of this court's precedent and the circuits and hold that a foreign government can unilaterally compel testimony and then the FBI can say, well, we didn't do it, so we can offer it at trial, especially in light of the fact that the Fifth Amendment says, as I stated before, that you have the right to not be compelled to be a witness against yourself, and that is inherently a trial right.
I just don't see why. You might be right, but if you are, I don't see why it stops with foreign governments, why it doesn't reach any coercion
Well,
by
Your Honor,
anybody.
because the facts of this case could, and the court could certainly write its opinion to limit it only.
Would you object to that?
We would, Your Honor, because it's outside the scope of what this court decided in United States v. Solomon, where they specifically
We
held
can't
on that
overrule
issue.
that, can we?
Well, we're not asking this court to.
I know, but if we were inclined to do it, would you object?
If the court were inclined to necessarily object, because that's within this court's purview to decide what cases are still valid, but we're not asking the court to do that. And moving to my second point, Your Honors, the government has no right to enter in a post-arrest silence, especially in response to an accusation made by law enforcement. If I may quote directly from Miranda versus Arizona, the prosecution may not use at trial the fact that a defendant stood mute or claimed their privilege in the face of accusation. That is exactly the type of circumstance that we have here. And quite frankly, to your line of questioning, Justice Donnelly, this is the functional equivalent of interrogation. And on that point, the Second Circuit in Nelson versus Familetti held that even when a defendant was simply asked if they would assist in the investigation, that was the functional equivalent of interrogation. Furthermore, the Ninth Circuit held in United States versus Brown that when a police officer accused a person of selling dope to little black children, that was the functional equivalent of interrogation. And especially Brown is very similar to what's going on here, because Ms. Spector is literally accused of helping people kill Americans. And that's a highly inflammatory statement.
Well, the litany you go through in those cases, those facts may be appropriate, but isn't the real question here the tipping point is, when is it invoked? That's the question. In spite of those facts you're talking about, because obviously there's no right to remain silent, right? Police officers can approach you and say, ma'am, sir, may I ask you a few questions? You can approach, correct?
Yes, Your Honor, in a consensual encounter, that's true. However, this was not a consensual encounter. She was under arrest at the time, and she was subject to the functional equivalent of interrogation. And on this point, we vehemently disagree with the government. The warnings don't trigger the rights in the Miranda context. The rights trigger the warnings. Once a person has been subjected to the functional equivalent of interrogation, then they must be Mirandized, and anything that they say or any silence that they engage in is inadmissible against them until and unless they are Mirandized. And in fact, in this way, the government's argument is patently inconsistent. On the one hand, they say that no reasonable person would believe that there would be a forthcoming incriminating response. And on the other hand, they concede, and to use the government's own words, that the silence was a response to the officer's statements, and then they try to use it at trial to incriminate her. Those two positions don't work together. They simply are inconsistent. And it's completely unfair to subject a person in these circumstances to this type of accusation and not even afford them the basic constitutional protections that this court has held for over 50 years since Miranda.
Do you have a non-constitutional argument that this just is irrelevant?
You-
Doesn't mean anything?
Your Honor, that would be a separate argument on an evidentiary issue, and I hesitate to make that argument.
Pretty
because
good argument.
It is a good argument, Your Honor. However, I hesitate because it's not properly before the court. The 14th Circuit did not rule on, and the trial court, for that matter, didn't rule on any of the evidentiary issues regarding 403 relevance or anything, or 401 relevance or anything like that, or even 801 hearsay. So those issues, they may come up later on, but they're not properly before the court in this procedure. And because of that, we simply state that the constitutional rights were violated in this case because the police the FBI were trying to elicit an incriminating response.
What would your position be if they had advised her of her constitutional rights and then said the same thing? Do you think the silence would be admissible then?
Well, Your Honor, if she had been advised of her rights, then the clear and unambiguous standard from Burgess v. Tompkins would apply, and a person would have to clearly and unambiguously invoke. However, post-custody pre-Miranda, we disagree with the government because in this case, we're talking about not whether questioning has to end, which is what Burgess v. Tompkins was really dealing with, but whether or not a person has the right to not have their silence used against them at trial.
So you think the bright line is custody?
Not necessarily, Your Honor. The bright line is as articulated in Innis. If there is custody and interrogation or the functional equivalent, then that would trigger the Miranda warnings. However, in this case, because even if this court were to disagree that this wasn't the functional equivalent of an interrogation, because Ms. Spector was still in custody, then she shouldn't be subjected to having her rights, her exercise of her right to remain silent used against her, because she wasn't trying to end questioning or end an interrogation. She was simply remaining silent. And in this way, and we would distinguish Salinas versus Texas because in Salinas, it was a pre-custody procedure, and actually Justice Scalia's three-judge plurality only commanded two other justices from the court. So even the court is unwilling to extend that rationale beyond three justices, and yet post-arrest, which is exactly the kind of circumstance that the Miranda court was concerned with, how then can we say that a person who is exercising their right to remain silent in the face of police conduct can have that evidence used against them at trial?
So if they hadn't accused her and done all these things, they just walked in and sat there for a while, could they introduce her silence then?
Not if she was under arrest, Your Honor, not under the rules we're asking
That's
for.
functional equivalent of interrogation too?
No, Your Honor, it wouldn't be the functional equivalent of interrogation, but because because the difference is they're asking to use the silence as substantive evidence of her guilt. And so it's not in the context of whether or not an interrogation has to cease, but in the context of whether or not that silence can be used against her as substantive evidence of her guilt. And that's what distinguishes this argument from the discussion in Burgess and in the discussion in Salinas. And so because of that, we can see
Well,
that
if you take that broad view as the use that determines it, then it would be in every case then. Whatever you use the silence for, that's the use of it. Are you saying you can't use silence as a substantive piece of evidence for the purpose of proving guilt?
yes, Your Honor, and that's consistent.
Ever?
Well, Your Honor, only if a person had already waived their Miranda rights and if they had signed the
So
form.
you mean to
and-
tell me if the case is someone is arrested for the murder of that child, and the police officer said after she was arrested, could they say, he never showed any remorse, never cried? That wouldn't be admissible?
Well, Your Honor, no, that would be inadmissible. For example,
Why
in-
not?
in-
Why
in
would
Uni-
it?
It would be inadmissible?
Why?
That would be inadmissible, Your Honor.
Why?
Because that would be a type of custodial silence that would be used against that defendant at trial.
Nobody says a word to him?
Yes, Your Honor, because the line for as far as whether or not a person has the right to not have their rights used against them at trial is custody, but the question of whether or not the questioning has to end as far as the
That's
Burgess
because you have a
decision.
right not to cry?
Well, you have a right not to respond at all, Your Honor.
But no questions. I think
Yeah.
that's what the justice is asking you.
No questions. It's
Well,
just-
Your Honor, I see my time is elapsed.
yeah,
May I briefly-
you may answer.
Well, Your Honor, even in that circumstance, if this court were to disagree with that assertion, it still wouldn't apply to this case because there was conduct on the part of the police, and our assertion is that that was the type of conduct that should reasonably be expected to elicit an incriminating response, and therefore the Miranda warning should have been given. Thank you.
Thank you, counsel. You have some time reserved?
Yes, sir. 2 points on rebuttal. First, requiring translators to be subject to cross-examination is a seismic and unnecessary change. Unlike Bullcoming, the translator is not offering testimony, and so there is no need to haul Mr. Maltz into court when an expert can adequately testify to the error of translation. Second, there is no functional difference between a private employer and a foreign sovereign. What's more, we don't want to provide foreign governments with a roadmap with how to disrupt United States investigations. And thus, the same sovereign principle must apply to this case. Thank you.
Thank you, counsel. Bill, you can adjourn the court.
All rise.
Our very wonderful and distinguished final round panel of judges to conclude their deliberation process. We have something that we would like to announce, not every year, but when we feel as though there is someone deserving. The Prince competition honors someone with the Lifetime Achievement Award that we have affectionately called the Princey. This is given to somebody who has demonstrated their heartfelt commitment to the competition, to the Moot Court Honor Society that puts on this competition, as well as the school. So we do have a recipient this year. So I would love to have the 2015 recipient of this award, Beth Palastro, is going to join me up here so that we can present this year's award to Christopher Gibbons. If he could please join us down in front. Let's stand for Chris Gibbons and give him an even more heartfelt round of applause here.
so much. Ah, come on.
Well, I'll do a little bit of introduction, and I'm happy to pass the mic off to Chris if you'd like to speak. But for anyone who goes to Brooklyn Law School, you definitely recognize Chris Givens. He is always all around the law school, helping everyone, not just the Prince competition, put on the millions of events that take place here, as well as so many odd jobs and dedication to the faculty, to the students. To explain everything that he does here, we would have to keep you until at least next week, and I'm sure we don't want to do that because we have a banquet tonight. But just to summarize, Chris is invaluable to the Prince competition, to the Brooklyn Law School community as a whole. So this modest award is all we have to offer you, but I hope that you can take it as a token of our appreciation for all of your hard work.
So I have no idea what to say, but so I'll keep my remarks short. You know, my favorite events to do. So I'm the director of events for Brooklyn Law School. Our dean, Nick Allard, certainly keeps my life very interesting and busy, and that's a good thing. But the favorite events that I get to take part of are always the ones that involve our students. You know, our job is to support them, to give them the best experience they can have at law school, and so those are the ones that mean the most to me, and that's why this award means a lot to me. Thank you.
Everybody see that? Go ahead. The bailiff said I can go ahead. Thank you. Well, I have the unenviable task of doing almost the impossible, but it's required to make it possible. That is to announce who the winner is, because that's clear. Both teams are. I mean, I think that's clearly so. And right now, while there's no statement of one divided the other, let's give them a big hand again. Thank you. And it is my pleasure to announce that the winning team is Team 36. Great job. All right. My dear colleagues, to the right.
Well, I, first of all, just want to say what a pleasure this was to, first of all, an excellent problem, I must say, and a difficult one with a lot of challenging components to it. But I thought you all were so poised and so knowledgeable about the subject, and it was so engaging, and to have lawyers, which is what you were very good lawyers today, and I think you should all be very, very happy with your performance. It was great.
I agree. I also want to congratulate the people who wrote the problem. I thought it was a very interesting problem. And I thought you all did a really fine job of finding and understanding and arguing the subtleties of it. I would say that overall, and I'm not going to speak about any individual person, I felt that I would have liked to hear more about why the rule you were arguing for made sense, in addition to why this case or that case stood for the proposition that you were asserting. After all, we're a court that can ignore the precedents if we want to, although we might be influenced by them. And so, in such a court, arguing about what other courts have said, lower courts have said, it's not irrelevant, but it's not the most important thing, probably. And so I guess I would suggest the next time you argue, and that'll probably be a real case, I suppose, you try, judge the court that you're in and give as much attention to why the rule makes sense as to why it follows what other courts have said.
Well, I certainly want to echo what was said by my dear colleagues. Doing a great job. First of all, just the stamina. This is the third time today? And you seem like your first time you argued it in a sense of the freshness and that nothing was jaded and like as if you knew what was coming, and I love that. You were energized. I thought about this, don't laugh because the audience hears how young they are, but I graduated from law school 40 years ago, and my law professor, John Reed, who was my evidence and still pro professor, died last week, and the dean of the Michigan Law School wrote a letter, but he'll be very proud of all of you in terms of how you just elocuted, in terms of just how sharp you were, and I'm very proud of you as well. Just some broad things, great eye contact, good presence, and just sort of give you a little Fourth Circuit type kind of experience that always look out for the friendly response from the bench. Sometimes we're not barbing at you, instead we're trying to give you something. And that was a big, beach ball was thrown out there, and sometimes grab the beach ball. Grab the beach ball, understand that, and also too, when there's some things you can let go without letting your case go, in the sense that get back to the practical side. What should we do? What is the right thing? What is justice? How looking at, and it's broader than sometimes the case law. In particular, you're absolutely right. The precedent is made right here, and while you are there in the crucible, add to the crucible, and that's what you do. We're here because we want to hear that. So, and all of you, I'm telling you, I look forward to seeing you in the Fourth Circuit to argue. You did a great job, and I congratulate you all. Thank you.
So at this time, I'm going to ask Brooklyn Law School's Dean, Dean Allard, if he could please join us up here. He's going to be giving us a little introduction to our very distinguished judging panel, who we've just heard our comments from. So they spoke about you guys. Now we're going to speak about them and give them the proper introduction that they deserve. So Dean Allard, I'm going to pass the microphone over to you if you're ready.
So, thanks, Meredith. My wife Marla says if I ever wrote an autobiography, the title would be I Digress. So, why try something new? I'm actually today at this moment overwhelmed a little bit by a personal experience I had earlier in the day, and it makes me very much want to encourage each of you to capture this moment and look around at those around you and that you're working with and realize, maybe you might think about this in a few decades from now, that the seeds of friendship and knowledge and experience and skills and professional qualities that you're acquiring right now are going to go on and bear rich fruit for many years ahead. And so just think about that maybe sometime along the way. This afternoon I gathered with a group of my law school classmates. I think probably General Underwood knows many of them. And we were meeting, possibly for the last time, with one of my classmates, Peter Kougazian, who has been long serving as a chief narcotics, major narcotics prosecutor with the Manhattan District Attorney. And he has been our class secretary, and he is a stand-up comedian, a magician, and he is one of the most wonderful men. And he's been suffering and struggling, unfortunately, with Lou Gehrig's disease, ALS, and now, tragically, as somebody who has spent his days like you are working to do on rising up on his hind legs and making effective arguments on behalf of the people, has lost his voice. But he's got one of these contraptions. I said to him it was kind of indecent that he stole Stephen Hawking's, where he's able to type in text and then the device speaks. And so he was very much, engaging. I got to tell you, he was still funnier than any of us using this device. But when I was sitting there with him, and I've been doing a lot of this, thinking about this, and with my classmates, many of them who were gathered, the dean of technical school up in Cambridge, I think it's called Harvard, and some other prosecutors and highly successful litigators and everybody. I thought how humbling it was to be with these people who I've learned so much with and so I admire so much, and so keep that in mind. And also, I really would like you to realize this is a tough moment. There's many days where I'm sure you are, I am, just watching the rip from the headlines news. You feel moments of sadness and concern, but be optimistic. And one of the reasons I'm personally optimistic, it's a big reason, is I look out at all of you and see what you've accomplished and what you're doing here. And this is a time when we need heroes, and that's what lawyers have always been. Lawyers, and you are now. You haven't yet. The local bar is going to have something to say about it, but for all practical purposes, you are all fully grown lawyers now. You're acting like it. Certainly these two wonderful teams are acting like it, and we need you to do what lawyers have always done, which is to be the guardians of our democracy. We need you to be the architects of economic opportunity. We need you to be the builders of bridges against these broad chasms of dispute and builders of peace. We need you to be the defenders of justice, freedom of expression, freedom of belief, freedom from want and fear. And those are the things that lawyers do. And so I thank you in advance for taking on these big issues that we're facing right now and making a difference. And don't be daunted by how big they are. I just remind you all of two things before I move on to my real responsibilities here. I just remind you all of, first, what Sir Edmund Burke said famously, which was that nobody made a greater mistake than he who did not, a person did nothing on the basis that they believe they can only do a little. All right, so just keep chipping forward. And the second thing is that you all are good enough. You are extraordinarily talented. You're now equipped with your legal knowledge, which is the most powerful tool known in the history of mankind to advance the human race. And you have the blessed energy and impatience of youth to overcome the defenses of the powerful and the privileged, and to make a positive difference, and also to overwhelm the complacency of your elders like me. So get going, stay woke, and be good. And I thank you all. So, not a sermon, just a thought. Forgive me. So I really want to welcome and thank our extraordinarily dedicated panel for the 33rd Annual Prince Competition. I think I'll start with the Chief Judge of the Fourth Circuit, Chief Appellate Judge of the Fourth Circuit, Roger Gregory. He's an extraordinary man in many senses of the word, and a true pioneer. When he began practice and founded a firm in 1982, he founded it with Doug Wilder, who, being living in Washington at that time, we became very familiar with and admired. Doug Wilder was the first black governor in the United States, elected governor. And Roger Gregory, Judge Gregory, the chief, became head of litigation in that firm and had many, many years of success. He was nominated by President Clinton, and the Senate refused to act as the election went on in 2000. So now think about this. Think about how disturbing that time was, the time of Clinton Bush, and then how far we've come. Arguably, no, definitively in the wrong direction. So I want to make a point here, and that is that when he was nominated, the Senate did not act before the election. But after the election, President Clinton nominated Roger Gregory to sit on the Fourth Circuit by recess appointment. And so all of you technocrats, all of you experts know that that means that appointment would have expired at the end of the first session, or at the end of the next session, which was the first session of the next Congress. However, think of this. George W. Bush appointed Roger Gregory to the bench, and it was his first appointment to anybody in the Fourth Circuit, and the Senate confirmed 93-1. So even in that time of great dissatisfaction and dissent, we still were marked as a people and a government that had more in common than not in common. And so I just take that as a tribute. It's also a 93-1 vote is a tribute to the quality of the man who was appointed to the district bench and then ultimately became the chief judge. Now, as all of you know, and many of you be clerking, and Lily, our graduate here, and Starr, who has won I think one of the highest, if not the highest, honors that our faculty upon her graduation does bestow, and was editor-in-chief, editor of the Law Journal? Right. So, remarkable woman. Also worked with the one and only Chief Judge Sheila Kay, the late Chief Judge Sheila Kay of New York State, and was responsible for the volume that is incredibly powerful in honoring her. So we're very grateful that demonstrating his great wisdom and judgment, the judge has had Lily serving with him as his clerk. So we're extremely proud to have you here, Chief. And especially the responsibilities of a chief judge, I know, are enormous. In addition to his caseload, he bears the administrative responsibilities. He serves for the Fourth Circuit on the Judicial Conference, and he also has to fulfill his responsibilities of helping develop the policy where there are policy issues for the First Circuit. So it's very, very terrific to have you here with us. So then I'll turn to one of our favorites here, Judge Ann Donnelly, who is more recently been appointed and confirmed on the Eastern District. She had served as a prosecutor for New York County for many years, and in different senior trial capacities. And she subsequently served in the New York Court of Claims, and she was a judge of the New York State Supreme Court in Bronx County, Kings County, and New York County. So that's a pretty good trifecta. And then also a special term for elections. In November, she was nominated by Barack Obama and the Senate, confirmed here in its wisdom. Judge Donnelly is one of those so-called judges that you hear about sometimes from the orange elephant in the room. She is, yeah, that was pretty good, I thought. We at Brooklyn Law School vividly remember this when many of our students and our faculty were on the steps of the Eastern District when an order was granted which blocked or barred enforcement of the travel ban on Muslims in this January. It seems so long ago now. It seems like it's a decade ago, but it was only a little more than a year ago. And it was Judge Donnelly that issued that order, along with other judges that followed suit. That kind of action, I think, that kind of action, like the majority opinions in overturning the ban on same-sex marriage that Chief Judge Gregory penned, or his ruling, I believe, also on the travel bans as well, correct? So we have two so-called judges here that we're very proud to have. He also has stood up, and it's those kinds of exercises that demonstrate to people the importance of the rule of law. It demonstrates a civic type of understanding that is so important for people to agree to abide by the rule of law, to understand how it works. And it's a wonderful, another reason for us to be in awe of our brilliantly engineered, cantilevered form of limited democratic self-government, to see how it all works. This is one of the reasons why I still remain an optimist. So I'm left with introducing to you, and this is the oddest part of the Prince competition. It's like the end that the stars get introduced. It's strange. And even the stars who are arguing, you know, it's kind of mysterious about where you come from. What school are you from? Good for you, Liberty. And what's your school? UC. Every year, come on. It's unbelievable. It's fantastic. Good for you. And an independent law school, so that's great. Sort of independent, but it's great. Barbara Underwood has had an incredible career, and she's currently, as you know, the Solicitor General of the state of New York, has served under three governors, Governor Spitzer, David Patterson, and currently Andrew Cuomo. After graduating from law school, she had a hard time finding a job. She started off clerking with the Chief Judge of the D.C. Circuit, David Bazelon, who was a legend, and moved from there with the iconic Justice Thurgood Marshall. So that's how she started. And then began working on the faculty of Yale Law School, that boutique in New Haven. After a long period of time teaching at New Haven and in scholarly work, she moved to Kings County, Brooklyn, and began working with also, in my day, the iconic Liz Holtzman, who sometimes judges Moot Court here and who we love, and my wife Marla worked for as one of her fundraisers back in the day. But she also continued to teach, and so from Yale, she taught at NYU and then at Brooklyn Law School. So her academic career has continued in an upward arc, you know, throughout all of her years. She's also argued 20 cases before the Supreme Court, which is amazing, and you can tell from her confidence and the quality of her questions and preparations that she's been around the barn a few times on these kind of presentations. She's served in the States, but also was under the Chief Deputy Attorney General, the Chief Deputy Solicitor General, say that a couple of times fast, in the Clinton administration, and then ultimately became the acting Solicitor General, the first woman in history to serve in that capacity. She served as a prosecutor here in Queens County and Kings County, and then also became a chief assistant prosecutor and a principal counsel for the United States Attorney in the Eastern District. So you know that she was appointed, and she's been working on many important issues, arguing before the courts here as our Solicitor General. We're very grateful for her also. Always good to see her return to Brooklyn Law School. We have Judge Donnelly, and I can't believe on St. Patrick's Day I got that wrong. Judge Donnelly and Judge Underwood are both Brooklyn residents, so we're particularly proud to have them. So please give this panel a big round of applause. So The writing team has been acknowledged in a general way. I think they deserve to be recognized in a specific way. I'd ask all of them to stand up and be recognized, and let's give them a round of applause. Ann Conroy, Jamie Filet, Anusha Kashima, Jessica Laredo, Rachel Poland, and Libby Viller. Now, Beth Pelasco's mother is here. Is that right? Is she still here? Or have I sent her fleeing? Where are you? Right back there. You did good. Beth is the driving force behind the scenes, organizing and worrying this program to perfection. And thank you. Where is she? Is she? Oh, you're next to your mom. Okay, you're nearby. I notice you're further away from striking distance, so that's really from experience, yeah. It was a really nice meeting your mom. Thank you, Beth, for all that you do. Chris Gibbons is the most can-do, capable guy I've known. A dirty little secret is that he's not only the events coordinator, he is a fabulous writer. There's a lot of times when I have a tricky thing to write that he will do that. And my biggest fear, we have all these movie filmings and TV shows. Elementary and Bridge of Spies, for example, was filmed in here. And just yesterday we had The Enemy Within being filmed over at File Hall and outside. My biggest fear is that some movie crew that he's helping will take him away, and not for helping be, an on-location logistical maven, but because just last year somebody put him in a police uniform. He's a pretty good-looking cop, so I think maybe Hollywood beckons for him, but I hope he stays here while I do. The faculty advisors of the Prince competition, Judge Stephen Gold, what an asset to the school. Thank you for your love and care and concern and the quality of what you do. Thank you. Professor Cameron Arnold, he's fantastic. A faculty advisor of the Moot Court Honor Society, the one, the only, the indefatigable Stacy Kaplow, Professor Stacy Kaplow. Now, I think this is the first, I haven't seen Ursula, so I don't believe she's here. Well, tell her I gave her a shout out. So the friends here, and Ursula Bentley, who's now emeritus, usually always comes. She was here earlier today, but she was really the founding faculty person that got it all started, and then also was joined later by Professor Emerita Molly Falk. And so I don't know if Molly's here, but also please pass on that we were thinking about them. I will just mention that there are people who have been incredibly, indelibly involved who are no longer with us. And all of them have fairly recently passed away. But don't worry if you're involved with, because they're all, at relatively, full and long lives. Bob Pittler, the pit bull, we've mentioned every year. His bio and description is in the booklet. I encourage you to read about it. Neil Cohen we lost, sadly, all of a sudden, quite unexpectedly, at the beginning of this year, and so we miss him a lot. I will mention also, and you might be interested in we lost a great Irishman, Professor Dick Farrell, who was intimately involved in the various editions of the Prince evidence, Richardson evidence, compendium. That's not the right word, but that's what it is. He worked on that, and he was with this law school for 50 years. Now, he was, in many respects, very popular, unusual, an acquired taste, a little bit off-center, and sometimes approached the line on being naughty. And I will just share with you, and the people from out of town haven't heard this, and I'm going to ask Larry, Professor Solon, who I see, and Cameron, and Stacy for forgiving me for retelling this story, but it's just to show that these people, these vivid people in our lives, never really leave. Well, that's what I thought was the case with Dick Farrell, because as soon as I sent out a few weeks ago the details to our community of his 2 wakes on Saturday and Sunday and his funeral, I got a return email from Dick Farrell, which said, one sentence, "I'll be there all 3 days." Right? So I thought, this is totally crazy. What is this? And I suddenly realized that his 4 sons had come in that morning. They were in his office, like cleaning it out. So I went down there, caught him red-handed, They were a little sheepish, but he had given them the password. He was trying to find the Prince edition draft. And I said to him, okay, your guys' email privileges are denied. We're closing you down. But not before I put an out-of-office message on here which says, I'm gone and I won't be back till hell freezes over. Anyway, I'm going to ask Meredith to take over. You'll be very grateful that she does, I'm sure, after this long monologue. But I just want to tell you the pride and the joy we all get from watching you all do so well. Thank you all for being here, and thank the bench again.
Thank you so much, Dean Allard. I have the very enjoyable task of announcing some of our other awards. We've already heard about our first place winners today, but we do have some other awards to give out. So we're going to be starting with the third best brief in the competition, which goes to Team 14, Western State College of Law. Please come up for us. Next, we're going to go to the second best brief in the competition, which goes to Team 30, UC Hastings College of Law. Please come up. Okay, and that brings me to the best brief of the competition, Team 36, Liberty University School of Law. The next award that we're going to announce is we recognized the best oralist in the preliminary rounds of the competition only. So we would love to have Katie Berger from Team 20, Ohio State University Moritz College of Law, come down. Next, we would love to recognize our second place team, Team 30, UC Hastings College of Law. Stand up again, ladies. Congratulations. And of course, as we have already announced, Team 36 are our winners today from Liberty University School of Law. Congratulations again. Our final award is the award for Best Oralist in the final round of the competition, which goes to Alex Stouch from Team 36. So now I'm going to bring up the president of the Moot Court Honor Society, Megan Shaw. You saw her as the bailiff in the final round, as well as running around behind the scenes with us. So please give a round of applause for Megan Shaw, our president.
Hi, everyone. I'm going to keep this brief because Dean Allard did speak a lot about who we would like to acknowledge and who we want to thank for making the Prince competition what it was this weekend. But on behalf of Brooklyn Law School and the Moot Court Honor Society, I do want to extend the important thank yous and make sure that they are acknowledged. We do have some gifts here. So first, we'd like to thank Chief Judge Roger Gregory, Judge Ann Donnelly, and Solicitor General Barbara Underwood for joining us this weekend. What a privilege it has been to have such a distinguished panel presiding over our final round today, and we're so grateful to have you here. And we'd next like to thank Dean Allard for his continued support of the Prince competition and of the Moot Court Honor Society. Our successes have been made possible because of you. If you can come up and join us, we do have a gift we'd like to give you. And we'd also like to thank a few members of the faculty who serve as advisors to the Moot Court Honor Society. Dean Stacy Kaplow serves as our general faculty advisor and has year after year served as a resource and support to our entire executive board. Professor Cameron Arnold and Magistrate Judge Stephen Gold are two faculty advisors to our Prince competition writing team. They've worked alongside our writing team this entire year to ensure that the record is in tip-top shape for both the competitors and the judges. And Beth Pilastro, the Student Academic Organizations Coordinator, who supports countless different organizations here on campus, but always always makes time for us and for the Prince competition. We thank you, all three of you, or all four of you, excuse me. If we can have each of you come up and join us, we do have something we'd like to give you. And I would be remiss if I didn't again acknowledge the 6 students that wrote this year's record. 3 all getting some tears. Ann Conroy, Jamie Freilich, Anusha Kashima, Jessica Laredo, Rachel Poland, and Libby Viller. It is no hyperbole to say that we would not have a competition without these 6 students, their hard work and their dedication this year. But there is no person who has put more time and effort into this competition than you 6. It is with such pride that we have had their work product representing our school and our society. Though one of the writers and one of our fearless executive board members couldn't be here today, Anusha Kashima, we would like the rest of you to come up here and take the gift that we've gotten for each of you. There are a few other names we'd like to acknowledge as what we'd like to call the lifeline of the Prince competition. Chris Gibbons, Mike Licari, who have once again made this weekend go off without a hitch. And Professor Ursula Bentley and Professor Mary Falk, the heart and soul of the Dean Jerome Prince Memorial Evidence Competition. Even though we may be celebrating the competition's 33rd anniversary today, we celebrate you both for laying the foundation on which we hope to continue to build. And last but certainly not least, thank you to our Prince Competition Coordinator, Meredith Cohen. I'm sure we can all imagine that this job is not an easy one, so we extend our deepest thanks to her for her efforts this year. So if we can all give Meredith a round of applause.
Thank you so much, Megan. I'm going to set these right here. I promise I'm not going to speak long. We've said a lot of thank yous today, so I'm going to keep it brief, but I could not leave today without specifically extending some extra thank yous. First and foremost, I'd like to thank all of our competitors. This has been such a huge undertaking, and it's all made completely worthwhile by seeing all of you here today and seeing the names that I've corresponded with via email, in person, and hearing truly spectacular oral arguments. So thank you so much to the competitors and the coaches from each of the teams that came. Also to all of our judges, especially our final round panel, again. But all of the judges from the preliminary rounds to the final have taken so much time out of their schedules to come here at my and Beth Palastro's requests. So I'm deeply thankful that all of them took so much time. We've spoken a lot about the events crew here at Brooklyn Law School, so Chris Gibbons has I think, blushed enough today, so I think I'm going to stop. But finally, just a huge thank you again to Professor Cameron Arnold, who met with me so many times and helped me put out so many fires and helped me keep on track. So thank you so much, Professor Arnold. I could not even move through this at all without Beth Palastro. I'm not going to talk about her because I'll probably get a little teary because I'm stressed and appreciative, so I will keep it very short and just say a huge thank you to Beth Palastro, who allowed me to invade her office and her personal time so often, and thank you so much for your assistance, Beth. Finally, just a quick personal thank you so much to Paul Jang, who spent a lot of time in my office and helped me with a lot of things. He knows that. So thank you so much to him. And then the Prince Committee of our students who just dedicate their time and help with, for no other reason other than their dedication to the society. So thank you so much. You've made all of this possible. Our e-board that we have standing over here are some of the hardest working individuals and kindest individuals that I've ever met, especially our fearless leader, Megan Shaw, who has helped me so much. Let's give everyone a round of applause on the e-board. When I was about to lose my mind a couple times this weekend, Megan found it, so thank goodness for that. But thank you again to everyone. This is the conclusion of our very long thank yous, because there are so many to say. So thank you all for coming. We remind you again, we'd love to see you at the banquet this evening at 8:30 in Forcelli, which is located at 205 State Street. We hope we see you there and at the after party that follows. Again, thank you so much for everything this year.